Good morning, Your Honors.
Good morning.
My name is Michael Fellows, and I'm representing Anthony Eberhart. There are two issues that I'd like to focus on in my argument today. The first is the question of whether the defendant's motion for a required finding of not guilty at the close of the Commonwealth's case should have been allowed where there was no evidence presented as to whether Mr. Eberhart had a license to carry a firearm or an FID card. And the second one is whether simple assault and battery, as it's defined in the Commonwealth, can be used as a predicate offense under 26910G, Armed Career Criminal Act. My basic argument with regards to the first is that McDonald has essentially overturned the reasoning in Commonwealth v. Jones. Jones was...
But why? When McDonald is a case that, at least on its face, is talking about what happens in the home, and this is a license to carry,
well, I think
and McDonald makes clear that it's perfectly fine for states to have regulatory license laws with respect to guns, generally.
I think that to look at Heller and McDonald as limited only to the home is, in my view, is a mistake. There's two places, at least in McDonald, where Justice Alito first says that the right, the core, the citizens must be permitted to use handguns for the core lawful purpose of self-defense. And at another point, he says,
Arthur Home,
most notably in the home. It isn't limited to that. I also think that the court in Heller and again in McDonald, they mention a number of regulations that aren't called into question by Heller, including carrying firearms in places like schools and government buildings. So there would be no question at all that those regulations aren't going to be called into question.
It's one thing to prohibit it, it's another thing to regulate it in terms of license requirements.
Yes, but I'm not arguing that the license requirement itself is unconstitutional. What I'm arguing is that the Supreme Court has said now every individual has a substantive right to possess a firearm for the core purpose of self-defense. I would argue that it is not limited solely to the home. And the idea then, I mean, what Jones says is that there's a general prohibition against carrying firearms, and that there are certain exceptions to that general prohibition, including having a license, an FID card. McDonald and Heller now say that there is no general prohibition against carrying a firearm. There can't be. That would be a violation of the Second Amendment. So that what is illegal now, what is unlawful, is having a firearm without a license. The state still has...
But, I mean, whether you want to call it, well, however you want to term it, isn't that how we have always interpreted our law? To be, I mean, as Couture makes clear. I mean, that in other words, it is having a firearm, carrying a firearm without a license.
But the difference is now that the lack of a license becomes the essential element of the crime, not an essential element. I mean, it can't be an affirmative defense anymore, as Jones said, because it is the act that makes
well, the Commonwealth,
carrying.
If there's evidence, the Commonwealth needs to prove beyond a reasonable doubt that the person doesn't have one.
Exactly.
Yes. I mean, that's what Jones says also.
But that means that the defendant still has to come forward with some evidence that he has a license.
Correct.
Due process says that the Commonwealth has to prove every essential element of crime beyond a reasonable
Commonwealth
doubt.
does have to prove it. The question is burden of production.
They have to prove it in their case in chief, is what my argument is. And, you know, Jones refers back to Morrison v. California And there are a couple of things in Morrison where they talk about where the burden can be shifted. One is where the evidence has some sinister significance. Well, carrying a firearm now or having a firearm can't be considered something of sinister significance.
It also says if there's a rational connection between the presumed fact and the proved fact, correct?
If there's enough evidence for the defendant to come forward and repel that evidence. But, again, the evidence has to be something that's unlawful, and carrying a firearm is not unlawful. Carrying a firearm without a FID card or a license is what's unlawful. That is the illegal act now. The other part that Jones talks about, of course, is the convenience of proof. In the Commonwealth, there's an executive office of public safety, has a firearms records bureau, which keeps a database of every license and FID card that's issued in the state. So that there is no difficulty at all for the Commonwealth simply to request information. At that point, then, the defendant would be required to come forward.
You would say, Mr. Fells, let me just ask you this, because 10G has a whole lot of exceptions.
Mm-hmm.
Right? So I take it your view of this is that for the Commonwealth to prosecute somebody for illegal carrying of a firearm, Commonwealth is going to be required to prove not just that the person doesn't have a license or FID card, but there's about 12 others. You're going to have to go through every single one of those, correct?
Well, I can't recall all the others off the top of my head. I think there's
12 is probably an exaggeration, but there's a number.
If you're on a shooting range or, I mean, obviously there are going to be fact situations where most of those are specifically going to be completely irrelevant.
But I take it on your theory, the Commonwealth is going to have to put in evidence that these things aren't true.
Well, if someone's on the street and the exception is that they can have a firearm in a licensed shooting range, then the evidence, it's been proven. I mean, there's just no evidence that the person was at a shooting range. But I think, and McDonald's talks about, their decision may create a whole lot of litigation. That's part of the problem. But the ruling, they've mentioned in the House, but they've also left open, that the self-protection, most notably in the House. And it seems to me this is the beginning of some new jurisprudence, Second Amendment jurisprudence. Obviously, it all still needs to be worked out. Today, I filed a 16L letter referencing a case out of the District Court, the District of Columbia Appeals Court, Harrington, U.S. v. Harrington. And that is a similar case, and it's the first one that I found anywhere where they actually overturned a presumption. This presumption was that that you had to have a license. This was for ammunition in the home. So it was squarely within what anyone would argue is Heller and McDonald's holding.
Now, in that case, was there a burden of production or a burden of persuasion? The last line of the letter, the quote says, puts the burden on the accused to prove facts necessary to establish innocence. We don't do that. It's just a burden of production, not a burden of persuasion on the defendant.
Right, but I mean, you have to.
Sorry, but in this case, was it a burden of production or a burden of persuasion that was at issue?
He had to. I believe it's the same as here. He had to come forward with some evidence that he had a license.
And then the state had to prove the opposite?
And then if there was a question about it, then the state had to prove the opposite. Now he had to have a license to have ammunition in the home, and that's what the case strictly holds to, and it doesn't.
And
they specifically don't say we're not answering this other question yet, whether it's larger than that. But
now, but in answer to Justice Botsford's question, I gather your ultimate answer is yes, the Commonwealth would have to prove beyond a reasonable doubt the absence of the exemptions as well as the absence of a license.
Yes, if there was any evidence. I mean, if it was.
No, it sounds like you're not saying that. You'd have to say that would be their burden. They'd have to because it has to be done as part of the Commonwealth's case in chief. So right now, it's if there is any evidence of the exemption, they would have to prove beyond a reasonable doubt that he does not fit within it. But you're suggesting.
Well, I guess I am. I mean, I hadn't thought about this exact question. So, and again, I don't have all of the exemptions.
Right. And I also assume with regard to the license to carry that that the person from that database would have to show up to testify. You couldn't get a certification that he's not in the database, correct?
Perhaps under Melendez-Diaz, it depends
Okay.
on, I suppose, whether the certification can come, if it's simply a reproduction of a document, or if it involves
Right, and I assume that
searching and
person then
analysis.
could be cross-examined as to whether or not there's instantaneous, whether the data from police chiefs with regard to licenses to carry are instantaneously incorporated into the database, or whether there's any lag time for that done, and whether or not this database is entirely up to date, or whether it's possible that a license to carry came in 4 days ago and has not been inputted. I mean, we have to deal with that kind of cross.
I suppose the date on the form would be important, or when the person checked. I understand what Your Honor's getting to, and obviously there are practical consequences of these kinds of rulings, but it seems to me, at least of late, the Supreme Court is not concerned with the practical consequences of what's their decisions. Melendez-Diaz, I was surprised, because I felt like the amount of money they're talking about just doing this wasn't going to happen, and then it did. And everything's been turned upside down. There's been a massive amount of litigation and much more cost and expense but if this is a fundamental constitutional right, then I think, again, the Supreme Court would say it doesn't matter. And in fact, they do say that. In McDonald, they say it doesn't matter. We understand that, but that's what happens when we have suppression hearings and all these other things with fundamental rights. It costs money, and it takes time. So in the face of a constitutional right, I don't think that those considerations can outweigh that. That would be my argument. I'd like to quickly get to the second argument. Simple assault and battery. As we know, there are two different kinds in Massachusetts. There's touching, however slight.
Can you tell me this? Because am I correct that the language of our, the definition of violent crime in Chapter 140, Section 121, is in all pertinent respects identical to the definition of violent felony in the federal counterpart?
Yes, it is identical, except in the last clause, the federal act actually seems to be more inclusive. Theirs says, or otherwise presents a potential serious risk of injury to another. Okay. Ours doesn't have the word potential. So there seems to be even, it only has to be a potential serious risk. Here we have to have a serious risk of injury to another.
Do you know, because I haven't done this work, whether there is, we passed ours quite a lot, many years after the federal government passed its. Is there legislative history, Massachusetts legislative history, that we were just buying into the federal definition?
I do not know. I didn't look into the legislative history of the statute.
One might infer that from the identity of language, but I just didn't know if you had looked at all.
I hadn't. I believe that basically we took it
word
directly from and the language, again, it is exact.
And the Johnson case that Holloway and Torres, whatever the other case is.
Torres-Rosario?
Yeah.
Yes.
Was decided when?
Torres-Rosario was decided...
No, Johnson, which both Holloway and Torres-Rosario are depending on.
Oh, I don't recall.
I guess my point is that the United States hasn't amended its ACC to reflect anything related to that, right?
No, I don't believe so. The way they look at it is that, and I think where you really get into it, I mean, it's supposed to be a violent crime, and then in the beginning it says physical force, the use, threatened use, or attempted use of physical force, or a deadly weapon against another, gives you an idea of the kind of force they're talking about. I don't think they're talking about
offensive touching versus harmful touching.
Exactly.
Or touching, however slight. I mean, even in the harmful, there's the language in Ford or something else about a touching, however slight.
Right. Well, but I don't think that we even need to get to that issue in this case, because there's no evidence at all of which kind. Was this an offensive touching, or was it just a simple normal A and B? The other part is the last clause in the statute, where it says, it talks about arson and burglary, explosives, and then it says, or otherwise presents a serious risk of injury to another. I think that the notion of what a violent crime is under 10G is something that has at least the potential to cause a serious injury to another. And obviously the offensive touching can be spitting on someone, I suppose, showering someone with your garden hose, or tickling someone is a case in the Commonwealth. These would not be things that could cause or have a potential to cause serious injury. And if there are no other questions, it looks like my time is up.
Thank you.
Thank you very much.
May it please the Court, Catherine McMahon, Assistant District Attorney for the Hamden District for the Commonwealth. In Commonwealth versus Powell, which was decided after Heller but before McDonald, this Court under the 14th Amendment refused to revisit Jones, Kuchar, and Cologne concerning the allocation of the burden of proof as to whether a person is licensed or has an FID card. In Lodeholt and in the Johnson case of last week, the Court declined to address the issue under the Second Amendment, where the defendants hadn't properly raised this procedurally for the Court. The defendant alleges that the basis for this putting the burden of production but not persuasion on a defendant has been undermined by Heller and McDonald, because now there's a limited right to possess a firearm in the home for purposes of self-defense. In this case, the defendant was an already convicted felon. He had at least 2 felonies, one for unlawful possession of a Class B controlled substance with the intent to distribute it, and assault and battery by means of a dangerous weapon, which are 2 of the enhancement charges for the Section 10D under Count 7 of the indictment. Both of those are felonies because they have possible state prison sentences of up to 10 years. So this was somebody who had already been convicted of 2 felonies, who was found on the street, not in his home, and he was found in possession of a loaded firearm that was concealed. It was in his pocket. It was not.
That goes to the sort of the facial attack or whatever, but that doesn't really deal with this burden of proof issue, does it?
Well, this is not a person who had a gun in his home. This is not a person who lawfully is entitled to have a gun because he has a felony conviction. In terms
you're saying he'd be ineligible to get a license?
Yes. And in terms of affirmative defenses, this Court has looked to whether it's something that it's more known to the defendant or more easily known to the defendant than to the prosecution. And as Your Honors pointed out, there's more than one exception, or you cannot carry a firearm unless, and there are several like subparagraphs of unlesses, and so to put the burden on the Commonwealth affirmatively in its case in chief to show that a defendant doesn't meet any of the exceptions, including I was in my own home, this was my home, the defendant should be the one who has to come forward with the excuse or the justification, and then it falls to the Commonwealth to disprove it beyond a reasonable doubt.
Do you think that... You go ahead.
So let me understand here. Does your argument turn on McDonald and Heller's, your view that it's limited, the fundamental right is limited to having a weapon in your home?
In terms that they've recognized a limited right, I don't see how it undermines Jones, as there's a general prohibition. If a person wants to say, I fall within an exception to that general prohibition, I affirmatively have the burden of production to show that I fit that exception, and then it falls to the Commonwealth to disprove that beyond a reasonable doubt.
So you're saying if this is the question of possession of a firearm without an FID card in a home, is it still okay to use this presumption in burden shifting?
The case that my brother submitted to the court under 16L today deals with the possession of ammunition in the home. And that was a case where in that jurisdiction, the defendant had the burden of persuasion, not just the burden of production. So that's one difference. And 2, that court limited it to we're talking about the constitutional right to possess a firearm or ammunition in the home. And in a footnote, I believe it's a footnote, the court says we're not talking about other situations. But in that circumstance, because of that constitutional right, it's up to the government to, and in that case it would be to prove that the person was not in his own home.
Well, this presumption, I mean, this is not only a burden of production. So if there's no, I mean, it seems to me that it also is a presumption. So if there's no evidence, ladies and gentlemen of the jury, of X, then you can essentially find him guilty of not having Y.
I think the model instruction or the standard instruction is there's no evidence, so it's not an issue. It's not that, therefore, you can conclude that he's
No
not
evidence,
licensed.
so it's not an issue. So the fact that you're charged with having a firearm without a license, because there's no evidence of a license, it's not an issue, ladies and gentlemen, that you should consider. In other words, that's sufficient. The fact that there is no evidence is sufficient to support a finding of guilty of not having.
And this court has repeatedly said that it's not an element.
So does Judge Zobel's decision in the Eberhart case undermine that thinking? Has she got it right?
Well, one, that's a joint venture situation wherein the defendant was going to have to show that his co-venturer did not fit an exception. And I could see that as a point of distinction.
Leave that aside for a second.
Okay,
Do you think that case is really limited to that fact situation?
Judge Zobel said that according to Couture, or Couture, however you want to pronounce it, it is an element. In Couture, the court said it's not an element. And since Couture, in Cologne, which is a pre-Heller-McDonald, and in Powell, where the court didn't go into extensive analysis of it, but under the 14th Amendment said, we haven't changed our view. It's not an element. It's an affirmative defense. And in Massachusetts, an affirmative defense doesn't put the burden of proof on the defendant. It's just the burden of production. The government always carries the burden of persuasion beyond a reasonable doubt.
And that's in fact how Jones defines what element means, is that the burden, to be an element, it has to be something that the government has to both come forward with production and proof.
Yes, Your Honor.
And so if you don't have production...
It's like any other defense or justification. I was recently looking into the reasonable use of force to effect an arrest by a private citizen. And it's an older Massachusetts case that adopted the model penal code, but it went into a discussion of what is an affirmative defense, and that's where you know what the reason is why you are allowed to do something, why you're justified to do something. You come forward in Massachusetts. Once you do come forward, it's up to the government to disprove that excuse or justification beyond a reasonable doubt.
Well, Judge Zobel, I think in the Gonzalez versus Eberhart case, talked about this going back to, was it Morrison, the U.S. Supreme Court analysis? Is it Morrison?
Yes.
Yes, and talked about the presumed fact. So in her thinking, the presumed fact here, unlicensed possession, must have a logical connection to the proven fact, that is, possession, right? So if you can prove possession, then it's presumptively the case that it's unlicensed. She said that's supposedly the logical connection, but she says, but possession doesn't even equal reasonable suspicion.
And Couture says two things. It says it's not an element that the Commonwealth has to prove, but it also said that the fact that someone is carrying a firearm without more isn't sufficient to justify a threshold inquiry. There are like two. One is whether you can stop a person. Another one has to do with the allocation of proof in a criminal trial. And where Couture says it's not an element, just that Judge Zobel says, oh, yes, it is, I don't think that's true. And what the court saying since Couture at least 2 or 3 times, it's not an element. It's an affirmative defense. So
her thinking about doing this presumed fact needs to be logically connected to the proven fact is not relevant when it's an affirmative defense?
Well,
unless it's an element? I mean, is that what you're saying?
Well, for murder, we always have to prove, the government always has to prove that it's an unlawful killing. An unlawful killing is one that's not justified or excused. But unless a defendant puts in, or the facts show some evidence of accident or self-defense of defense for another, it's not in play. And in the model instructions, if there's no facts of a justification or excuse, the model instructions say self-defense, defense of another, or accident. This case does not involve those. But we still have the burden of proving an unlawful killing, but unless a particular justification or excuse is raised by the evidence, the Commonwealth doesn't have to disprove it beyond a reasonable doubt. I'd like to turn to whether simple assault and battery can be a predicate offense under the Armed Career Criminal Act. In Johnson versus United States, the United States Supreme Court said that for violent felonies, simple assault and battery with force, however slight, cannot be a predicate felony under the federal ACCA. In Commonwealth versus Ware, the appeals court noted that our Armed Career Criminal Act is essentially taken almost word for word from the federal act. But nonetheless, it's Massachusetts put in force. And what the U.S. Supreme Court did was, in going into whether an assault and battery constitutes a predicate offense as a violent felony, first jumped to a dictionary before jumping to a legal definition of force in assault and battery.
Doesn't the federal act also use the word force?
Yes, and it uses physical force. I looked through Massachusetts statutes, and I tried to find in case law physical force, which was different from the usual sense of force of it's however slight, or the degree of force is immaterial. For assault and battery, it's force however slight.
Well, but before you even get there, if you've got the Massachusetts legislature incorporating the federal statute,
They incorporated the federal statute.
I mean, and with no, I don't know, but is there any indication that, no, we mean something different? We're using the same words, but we need something different?
Well, Johnson came down several years later after some courts had said that simple A and B could be.
But I take it Johnson is interpreting what the U.S. Congress meant when they passed the federal
Yes.
ACC, correct?
And it says that the force, for physical force under the federal statute, is force capable of causing physical pain or injury to another person.
Yeah.
The dissent said usually you look to the statutory construction. Generally, that's what we do here in Massachusetts. If the legislature hasn't defined something, we look to where the legislature has used the words before.
But why wouldn't we just look to, in this case, because of the identity of language, why wouldn't we look to the federal statute?
Because we enacted the statute before the U.S. Supreme Court decided that A and B didn't fit.
You haven't done anything since.
I found nothing addressing assault and battery at all in Massachusetts. But there's harmful batteries and there are offensive batteries. There are intentional batteries and there are wanton or reckless batteries. Recently in Holloway, which is a case cited by my brother in another one of his 16L letters, the First Circuit said that a wanton battery, which always requires harm, cannot be considered a predicate offense under the federal ACCA because it's not purposeful conduct. So did Massachusetts, in enacting the federal language similar to the federal statute back when we passed it, also accept like federal courts' consideration of Massachusetts statutes which weren't before the Congress when it adopted it?
Quite apart from that, I mean, if you look at the statute and the violent, the definition of violent crime, and you look at what happens with a first, second, and third level of ACC, don't you think it's pretty clear that the offensive touching would not be included in what is a violent crime? I mean, the statute includes burglary, extortion, and arson, not even arson of a dwelling.
So those are not necessarily violent offenses, but there's a possibility of violence. And very recently, at the end of October, the First Circuit decided that larceny of a person, because there's a potential of a violent reaction to it, constitutes otherwise involves conduct that presents a serious risk of physical injury to another, goes under that residual clause.
The federal ACC?
Yes.
Right, but under your interpretation, if a person on 3 separate occasions spat at somebody, he or she's getting not less than 15 years.
And Justice Alito noted in his dissent in the Johnson case that if a bar patron spits at another bar patron, the result could be retaliatory violence. There's a potential.
Years for that? Whew.
I was looking at this, and, you know, it's a violent crime. The reason why the U.S. Supreme Court didn't adopt the misdemeanor definition of force was because they were dealing with felonies. But their felony is, and A and B in Massachusetts is a misdemeanor, A and B on a police officer is a misdemeanor, but they're all punishable by more than 1 year of incarceration, so they fit within the federal statute. What is a felony has broadened over the years. But in the majority opinion, they thought that when you're talking about violent felonies, Congress would not be adopting a definition of a misdemeanor to fit within what is a violent felony. Here, it's violent crimes, which include misdemeanors, and some of the crimes here that are enumerated in the statute do not necessarily involve physical violence towards another person, although there's a potential of something. We just have the First Circuit saying that larceny of a person has the potential, not looking under the hood as to whether that particular larceny did involve some kind of struggle or escalated, but just because there's a potential, it fit within not the force clause of the ACCA, but the residual serious risk of physical injury clause. So,
Can I ask you, I know your time is up, but so you would reject the modified approach that Chief Judge Breyer suggested in Harris before he went to the U.S. Supreme Court?
I'm sorry.
In United States versus Harris, then Chief Judge Breyer said that A and B includes harmful touchings and offensive touchings. They're different. And one has to look not just at the crime, because A and B is a common law crime, which includes a lot of conduct. One needs to look at the facts. And that's sort of the modified approach.
And if we have to look at the facts, because there are harmful batteries and there are offensive batteries, that's established, long established law in Massachusetts, I agree. But if we take a categorical approach, so if you look at if somebody was charged and convicted of A and B, it does not give you any indication at all, as in this case, whether it was harmful or offensive.
Wasn't that the government's burden to sort of present some evidence on the underlying facts in this limited case where A and B covers such a wide range
If it's a
of conduct?
categorical approach, which is what Massachusetts is taking, you don't look under the hood. If you're going to look under the hood, sometimes it goes only so far as like the charging document or like a plea colloquy. We don't have that here. If the A and B, without any explanation about whether it was harmful, which is the fact of this case, all we have is he was convicted of assault and battery. Nothing beyond it was domestic, and I submit that that doesn't make it harmful versus offensive. It's a simple A and B. Then we did not meet our burden of proof here in this case for a 10G-C enhancement. But because of the two other predicate offenses, it should be remanded for, like, affirming it as so much as a 10G-B with resentencing. And if the court's going to consider whether it's the categorical approach, you stop there, or in other cases, because I believe this is pending and it's been under advisement since February in the appeals court in Commonwealth versus Jason Cologne, which is another A and B case. It's like, if you can look under the hood, like what's permissible to look under the hood? How far can you go?
All right, thank you very much.